Am I audible, ma'am?
Hi, yes, Aditi, you are audible.
Shall I start?
No, Aditi, wait for 2 minutes. Huh?
Wait for 2 minutes, Aditi. Yes.
Okay, ma'am.
Sir, shall we start now?
Hello, ma'am. Good evening.
Good evening, sir. Good evening. How are you, sir?
Yeah, good, ma'am. How are you, ma'am?
I'm also fine. Thank you, sir. Very happy to see you. Yeah, very happy to see you at this platform. Actually, physically, we would have invited you, but well, in future, we will be doing that also, sir.
Definitely, ma'am. Definitely, we will be there. Now
Shall
at
we start, sir?
your office or at your home, ma'am?
No, at office only, sir.
Oh, that is really dedication, ma'am.
That's the administration, sir.
Fine.
So, Aditi, start it. Sir, shall we start it?
Yeah, ma'am. Yeah, without any delay.
Yeah.
Yes. Aditi,
Okay, ma'am.
start. Yes.
Good evening, everyone. I'm Aditi Dhage. I hope you all are doing well today. We are gathered here for an exciting and thought-provoking guest lecture on the topic that is increasingly relevant in our interconnected world: contractual competence, understanding capacity, and its implications. We are truly honored to have with us Dr. Sohnu Saini sir, esteemed expert in the field of law. Currently, he serves as an assistant professor of law at Rayat College of Law, Rail Majra, SBS Nagar, Punjab, where he inspires and educates the next generation of legal minds. Now, I would like to request our beloved principal, Dr. Poonam Nathani ma'am, to give a welcome note for the program.
Thank you, Aditi. Respected our today's guest, Dr. Sonu sir. He's not only the guest, he is best friend of mine. And today's coordinator, Sheetal madam, all beloved students and dear staff. It is really my great privilege to welcome Dr. Sonu sir, who is an exemplary educator and distinguished member of law academic community. Sir, we are really very happy to receive you. What I have noticed when last time we were there together for a faculty development program at Jaipur, I noticed that your sincerity, your efforts, and your dedication towards the legal profession, it is really commendable. So even that time we thought of calling you, sir. And sir is expert in, especially in criminal laws. Sir, in next semester, we will be inviting you for CRPC also. I know it is on your tips, sir, fingertips, CRPC and IPC. And well, we are very thankful to you, sir, for accepting our invitation, readily accepting. In one invitation, simply he told, madam, whenever you are saying, I am ready for that. So, sir, I am very thankful to you for gracing this occasion and accepting our invitation to have an interaction with our students on the very basic topic, that is the competency of contract. Sir, especially this class is arranged for first year students, because this semester they have to appear for contract, they have that subject. So your deep understanding and your expertise in that area, definitely it will helpful our students. So thank you, sir, and hope that we will be having very good and fruitful session today.
Definitely, ma'am. Definitely.
You are not audible, Aditi.
Thank you, Principal Ma'am. Now, I would like to request coordinator of this lecture, Assistant Professor Sheetal Ghute Ma'am, for introducing today's guest.
Yes. Am I audible?
that is not necessary, and you given like in brief introductions me. That is fine. If
In short, sir.
okay, fine.
Yes, sir. Am I
Sir,
audible?
let our student
Aditi?
understand your achievements
Okay,
Yes.
in the legal field,
fine.
legal education field, sir.
Right.
Okay. Good evening, all. It is my pleasure to introduce our honorable guest speaker for today's lecture on the topic contractual competence, understanding capacity and its implications. We are honored to have with us Dr. Sonu Saini sir, an accomplished academic and legal professional. Dr. Sonu sir has a rich and diverse academic background. Sir is currently serving as an assistant professor of law at Royat College of Law, Rail Majra, SBS Nagar, Punjab, where he brings 11 years of teaching experience and research experience of 10 years. His diverse background provides him with unique perspective that combines theoretical knowledge with practical insights. He holds a BLLB from Maharishi University, Maharishi Dayanand University, Rohtak, and LLM from Punjab University, Chandigarh, and has recently completed his PhD from the same. Sir has published a number of books, chapters at national as well as international level. We are excited to learn from his expertise and shares valuable insights into creating effective contractual competency and related to it. Please join me in the virtual stage to welcoming Dr. Sonu Saini sir. Thank you, sir, joining us today. Now,
Thank you.
Aditi, over to you.
Thank
Thank
you,
you,
ma'am.
Sheetal, ma'am.
Now I would like to request today's distinguished resource person to deliver the lecture.
Good evening, everyone. First of all, I would like thanks to Principal Ma'am, Dr. Poonam Ma'am, Seetal Ma'am, and management of this college for inviting me this for this for lectures. And that is very crucial and very important for first year student because that is your part of your syllabus and for future career also, right? So without any delay, can we start, ma'am?
Yes,
Poonam,
sir.
Yes, of course,
Yes,
sir.
yes, sir. Yes, yep,
yeah.
of course. Yes.
Okay. Is my screen is visible?
Yes, sir. Your screen is visible. Yes.
Okay. Poonam मैम इसको जूम पे मीन्स टू से मेन स्लाइड कर देना है इसको. Okay. Yes, student. So today's lectures on the topic that is contractual competency, understanding capacity and its implications, right? So the word contractual competency, that means the legal capacity of the persons to enter into a contract. That is generally we can say it's related to Indian Contract Act, right? So this lectures will cover that is the basic about law and what is the law of contract, right? The second one of what is contract, and the third one's the essentials part of the contract with a special reference to the capacity and its implications, along with the case studies. That is very important for this chapter. And outcome of this lectures that would be the after this end of these sessions, the student will be able to understand basic about law and the natures of the Indian Contract Act, and lastly to understand the contractual competency of the parties, right? So before going to discuss, there is a two famous quotations. That is one of that is Nelson Mandela, the one said, the educations is the most powerful weapons which you can use to change the world. And the second one, the Francis Bacon, which says that the knowledge is a power. the educations provide the knowledge, and knowledge, as we know, that is power. If you have knowledge, then you can do anything, whatever you want in your life. So in the line of these quotations, so our topic will enrich your knowledge and definitely will help you in your life, right? So contractual competency, that means we already discussed that the legal ability to of a persons to enter into a contract, right? Which ensure that if the parties are competent, then the contract is enforceable and legally valid, and parties can sue in case of a violation of their contractual obligations, right? So this entire contractual competencies law, legal form, legal framework, that is regulated by the Indian Contract Act, sections 10, 11, 12, right? So before discussing these sections, just we should know basic about law, right? So and then after we'll discuss the basic about Indian Contract Act, and then the contract, what is contract, and then essentials, right? So law of contract, like that is divided into two parts, that is law plus contract. So what is law and what is contract, right? So any student, can you tell me the what is law in simple way? Any student? Yes, please, student, do participate.
Simple words, we can say law is a set of rules.
Right, very good. Yes, any others? Yes, student, please do participate. Rules. The purpose of law. The purpose of law.
To regulate the society.
To regulate the society, right? And the making body of the
human
law.
right, protect the rights our. Law is fundamental right.
Right. Okay, fine. And the law making power means who making the law?
Governor.
Governor.
Parliament.
Legislatures, right? Good.
Parliament is responsible for making laws of the country.
Okay, if then we have any law silent on any point, then who can make the law?
Chief Justice of India.
Chief Justice of India, right? Okay, very good.
Judicial
Excellent. Right, judiciary, excellent, dear student. So generally, as you stated, that the set of rule and regulations which is made by the parliament or by the legislatures, which is enforceable by the court, right? The purpose for that to regulate the government of state, to relationship between the organ of the state, and to regulate the conduct and community of the community conduct, right? And to regulate the relationship between conduct of the each other's organs, right? Even like state, government, and individuals, to regulate all these, that is in purpose of the law, right? And that is made by the legislatures, and in absence of that, then that is made by the judiciary, right? The best example in the line of our topic, that is the minors relating agreement, that is ab initio void, where it is written. Yes, any student? Minors relating agreement, ab initio void, where it is written?
Indian contract.
Indian
Section 10 of
Contract
Indian
Act.
Contract Act.
Very good. Which section?
Section 10.
Section 10. Okay, yes, any other student? Where it is written? So minors relating agreement, ab initio void, where it is written? Except section 10. Okay, so nowhere it is written that minors letting agreement is void. Section 10 just talks about the essentials qualifications for the valid contract and who can enter into a contract or who is not enter into a contract, right? Eligibility of contract, right? This there is an the leading case law, that is Mohri Bibi versus Dharmodas case law. In this case, the Privy Council held that the minors letting agreement is ab initio void. That precedent we are just today we are following that principle which is laid down the Privy Councils, and the Supreme Court in various judgments confirm this like a precedent, right? So in detail, we will discuss later on while we are discuss the case study, right? So the types of law, as we know, there is a two types of law, civil and criminal. We will not discuss in detail, right? Civil, that is related to generally the dispute between individual, organization and government, where the parties claim their right and the compensations, right? And the second one is that is related to criminal law, that is related to offenses against the state, right? So next is most important, the substantive laws and procedural law. Is can anyone student tell me the substantive laws? What do you mean by substantive laws?
The substantive law
Substantive
defines the rights, duties, and liabilities for the people,
Very good, nice,
while
right? So
procedural law is the rule for enforcing those rights.
right, very nice, very good. Right, substantive laws, that means which define rights, duties, and liability of the persons, right? So, Sales of Goods Act, Partnership Act, there is various types of law which talks about the rights of the persons, right? And to enforce these rights, which is decided by the substantive laws, that is a procedural law, which we can say which provide the machinery to enforce these rights, right? Hence we can say it's put the life in substantive laws, right? If there is no procedural law, then there is no relevancy of substantive laws. Okay, fine. Next question is that what is the nature of Indian Contract Act? Is it substantive laws or the procedural laws? Yes. Is it substantive laws or the procedural laws? Yes, please.
So it's a substantive law because it outlines the rules and principles. So I think
Right.
it's a substantive law.
Yes, any other student?
Both substantive and procedural.
Both substantive and procedures. Okay. How it is a procedure? Yes, better please. Sometimes this question may be asked from your interview, right? Whenever you will be appear for interview for a legal assistant, legal law officer, and a law advisor. That general question may be asked: what is the nature of contract? Contract Act.
No, sir. According to me, it's a substantive law only, sir. I don't think it's procedural.
Okay, fine. Right, fine, very right. It's a substantive in nature. That is, be clear means to say a special branch of substantive laws, because it's not provide the rights, it's not provide the duties, it's provide the circumstances under which a persons can enforce their rights. Suppose if there is an agreement between two relating to sale of goods, right? The seller's right and buyer's right, both are the defined by the Sales of Goods Act, right? And how it can be enforced according to the Indian Contract Act. What are the remedies that is provided under Indian Contract Act, right? So next question is that when Indian Contract Act was enacted? Yes. Can anyone tell me?
1872, no, sir, because
Right.
Indian contract
Date.
1872.
Right. 1872. Okay. Any date? A date for enforcement?
For September.
Of September 1872.
September.
September.
1st September 1872. Very nice. Okay. So in the line of the same, what is operation of law and what is enforcement of law? Please, anyone can tell me what is operation of law and what is enforcement of law in the line of Indian Contract Act? What is the date for operation of law? This is your Indian Contract Act, right? So can anyone tell me the date of operations? Yes, please. This is very, very important. Sometimes can also be asked from the interviewer in your interview. What is the operation of law and the date of enforcement operation of law? Yes.
The operation of law means that date automatically rule is applied.
Automatically applied. Okay. Yes. Anyone else? Yes, Peter, please. Okay. Operation of law means on the day on which date the law execute means enacted, right? Enforcement of law means on the day from which date law come into existence, right? The 25th April 1872 is the operation of law, and the first day of September 1872, that is a enforcement of law, right? जैसे recently जो हमारे criminal laws आए है ना, जो 25th December 2023, that is enactment date, that is an operation of law, right? जिस दिन a law बना है, मतलब all the process of law completed on that day, right? The second, the 1st July 2024, the enactment enforcement dates is then say applicable हुए है ना, so that day is enforcement date, right? So हमेशा याद रखना बेटा इस चीज को, है ना? That is these questions are very, very helpful in your upcoming interview, or that may be in your future, right? So fine. Now start the what is contract. Yes, can anyone tell me what is contract? Yes, Anali.
Legally binding agreement between two or more parties.
Legally agreement between two or more parties. Yes. Any others?
Agreement enforceable by law.
Yes, right. An agreement which is enforceable by law. That means to say contract. Section 2 has defined the same. And what is the essentials of a contract? Yes, please.
Two parties.
Age fact.
Offer and acceptance.
Offer and acceptance, right? Okay.
Competency.
Legal relationship.
Legal relationship. Yes, very right. Okay.
Consideration.
Legal consideration.
Legal considerations, right?
Lawful object.
There must be two parties.
Though there must be two parties, right?
Consent.
Lawful object.
Lawful object, consent. Okay, good. There is only two essentials. Very first is agreement. The second one is enforceable by law according to sections 2H. An agreement which is enforceable by law. Sections 2 as defined. That there is a two important term, that is an agreement plus enforceable by law. So what is agreement? That is sections 2E. What it says? That every promise and a set of promise forming the consideration for each other, means to say the promises which constitute the considerations, that is known as an agreement. And what is promise? The promise means the proposal when accepted, it's become a promise. जैसे ही promise proposal क्या होता है, accept होता है, that's become a promise. Or every promise or every set of promise forming the consideration for each other, that is known as agreement. And every agreement which is enforceable by law, that is known as contract, right? So offer and proposal. offer and acceptance, sections 2 and sections 2b. When section 2a says when one person signifies to another his willingness to do or abstain from doing anything with a view to obtaining the assent of that other. That is known as a proposal. Acceptance, when the persons to whom a proposal is made signify his assent thereto, the proposal is said to be accepted. And when the proposal accepted, it's become a promise. Means to say the first step, that is offer. The second step, acceptance, it's become a promise. The third step, that is promise. Promise plus consideration, that constitute an agreement. An agreement which is enforceable by law, that is known as contract, right? So some students said the two parties, some students said the offer and acceptance, huh? That is all fine. That is an essential agreement of that is essentials of for a valid agreement, right? ऑफर किसी का भी हो सकता है, एक्सेप्टेंस किसी चीज की भी हो सकती है, बट पहले वो क्या बनेगा, प्रॉमिस बनेगा, एंड प्रॉमिस के बाद नेक्स्ट बनेगा एग्रीमेंट, है ना. इफ दैट एग्रीमेंट इज एनफोर्सेबल बाय लॉ, एंड व्हाट इज एनफोर्सेबिलिटी बाय लॉ, दैट इज डिफाइंड अंडर सेक्शन 10, राइट. सो if we are see that sections 10, the main heading, what agreements are contract, है ना, means to say all agreements are not contract. Only those agreement which fulfill the terms of the sections 10, that is covered under a valid contract, means that is only enforceable agreement, right? So all the agreements are contract, all the agreements are contract if they are made by a free consent of the parties, means parties must be competent, right? Second one is lawful consideration and lawful object. The third one's not expressly declared to be void, and the fourth one, fourth one, that is miscellaneous. That is nothing herein contained shall affect any laws in the in India which is not expressly repealed by any contract is required to be made in writing or in presence of witness or any law relating to the registration of documents. Means if that agreement is registration is mandatory, or the witnesses and all are mandatory, then that is must. Otherwise, that is not enforceable by law, right? So the main important point, that is very first, that is the parties must be competent. The second, the consent of the parties must be free. And the third one, that is lawful object and lawful considerations and lawful object. And the fifth one, last one, is that not expressly declared to be void, right? So parties must be competent and cover under sections 11 and 12. The second one, consent and free consent, that is under section 13 to 22. And the third one, the lawful object and lawful considerations, cover under sections 23. And agreement which is not expressly declared to be void under section 25 to 30. So this is the like first part of Indian Contract Act, right? So entire Indian Contract Act divided into three parts. First one is formation of contract. The second one is performance of contract. The third one, a breach of contract. Section 1 to 36, that is related to formation of contract, right? So next, so 31 to 36, that is related to the contingent of contract, right? So next part, performance of contract, means whatever the obligations made by the parties, means the respective parties of the contract perform their respective obligations. Section 37 to 66, that is cover performance of parties, means जो भी obligations parties ने लिए that can मतलब perform their respective obligations, right? Next one is if the parties not perform their respective obligations, then this parties can file suit in a court for a breach of contract under section 73 to 75, right? Okay. Most important, that capacity to the contract, right? Sections 11 and sections 12, that is relate to the same, right? Sections 10 talks about the competency of the parties, who can enter into a contract or who is not eligible to enter into a contract, right? So next questions again arise that why the law required the competency to the contract? Yes, anyone can tell me why the law required the competency of the contract? क्यों required क्यों है competency? Yes, please. Please, student.
To understand the relevance and importance of contract.
Right. Okay, to understand the importance of contract. Okay. Next.
To avoid future
So basically, we can say it requires competency because so that to ensure that a contract is legally binding and it is enforceable.
Okay, fine. Next.
Sir, to avoid future disputes, if any, arises.
Definitely वैसे भी arise होते हैं बेटा. If there is an breach of contract, तो definitely arise होंगे. और क्या हो सकता है?
Incompetent persons cannot enter into the contract because it is void contract.
वो तो ठीक है बेटा, मैं ऐसे कह रहा हूँ क्यों required क्यों है? Why it is competency is required for a contract?
For performing obligations of the contract.
Okay. आप you all are maybe above 18, है ना? Right? So आप किसी बच्चे के साथ कॉन्ट्रैक्ट कर सकते हो. Can we आप इक्वल बार्गेनिंग पे होंगे?
No.
Definitely not. We cannot.
Definitely, है ना? Maybe exploit, right? Exploit हो सकता है ना?
Yes, he can be.
Definitely exploit हो सकता है. If you are all जो अब अभी 16-17 एज में अब कोई उनके साथ कोई कंपनी कॉन्ट्रैक्ट साइन करे, can we say both are the parties on equal footing? No, the parties can
No,
take
not at all.
definitely, right? So parties can take undue advantage. The parties may be exploit. So that's why this is the reasons behind it, Kibir. Parties must be the competent so that the parties can understand or understand the terms of the contract, right? So that are the reasons that may be because they are unable to protect themselves. You know, minors not means protect themselves, right? Second one is the maybe exploit by someone, or that maybe take undue advantage by the others, right? And definitely in India, the law protect the weaker sections like the minors, unsound mind persons. They are specially protected by the law, right? So Indian Contract Act also the same, right? Next one is who are competent to contract, right? Sections 10 specified the three categories of the persons who can enter into a contract, right? Number one is the according to the age of majority, according to the law. The second one is sound mind. The third one is not disqualified from the contracting by any laws, right? So यदि इनको opposite में लें, then who is not who is disqualified, means to say who is disqualified person? Opposite view. Who is not entitled to enter into a contract?
Answer me.
हाँ जी.
Minor.
Right, minor.
Qualified by law to enter into a contract.
Very good. है ना, disqualified by the law or unsound mind persons, right? These are the not eligible to enter into a contract, right? So next one is what is the age of majority? As we know, that is above 18, right? Next question is that who is sound mind and who is unsound mind? That sections 12, that is talk about the same. Right? It talks about the circumstances when the sound mind person can be entered into a contract and what is the consequences of the same. Right? Who is the sound mind? Means law presume that all are sound mind persons, right? Definitely हर किसी को सोचता है law presume यही करता है कि everybody is sound mind, right? Sound mind who can easily understand the terms and terms of the contract, right? So section 12 that talks about the circumstances when the sound mind persons or unsound mind persons can be eligible for contract or cannot be eligible for contract, right? So a person who is usually of sound mind and occasionally of sound mind can make a contract when he is sound mind. Means at the time of making contract, the person must be sound mind, right? If that person is unsound mind, then cannot be entered into a contract. Means to say, sound mind during their soundness, right? During their unsoundness cannot be entered into a contract, right? So most important that is at the time of entering into a contract, right? Must be sound mind. Contract sign हो रहा है उस time पे persons sound mind होना चाहिए, otherwise not eligible to enter into a contract, right? So the graph that is generally unsound mind, occasionally sound mind can enter into contract when he is sound mind, right? Generally sound mind, occasionally unsound mind cannot enter into a contract when he is unsound mind persons, right? So generally ये structure है so section 12 में during the sound mind can person enter into a contract but not during their unsound minds, right? So the persons is considered as an unsound mind persons generally, that is an idiot persons and delirious persons and mental decay and drunken persons and a lunatic. Generally it's not a permanent unsound mind persons, right? So these are the persons generally considered as an unsound mind persons, right? And next one is the nature of the agreement made by the person of unsound mind persons. Yes, can anyone tell me what is the nature, whether it is void or voidable? Yes, please.
Voidable, sir.
Sorry?
Voidable.
Voidable, right? Okay. Yes, anyone?
Yes,
Any
sir.
other?
It's void. This is
It's
void.
void. Okay. Okay, so there is a two laws, like one is the English law, the second one is Indian law. Both are the different on this point, right? If we are talking about the English law, that is clearly talks about that it's an voidable contract at the option of the incompetent to the contract, means to say at the option of the parties, right? And the second one is the Indian law that considered as a void agreement, right? That is not enforceable by law, that is not on binding on the parties, right? It was held in Amina Baby or in the Singh case, right? And Empirical Lawn Company versus Stone case, that is in England. In this case, the court declared that the agreement which is made by the persons of unsound mind persons treated as an voidable, right? So the situations relating to the agreement made by the persons of unsound mind persons, that is different in both the countries, Indian or English, right? So persons disqualified by law. Second, next disqualifications, that as we know that alien enemy or the convicted persons during their uh, imprisonment, right? If the permission of the government can sign the exam contract, but otherwise not eligible to enter into a contract. Next one is insolvent persons, you know, during the insolvency person is not eligible to enter into a contract, right? Next most important, that is basically which is related to our topic, that is the positions and the nature of minor agreement in India or in England. Yes, Anji, can tell me what is the nature of minor agreement in present scenario also?
Void ab initio.
void ab initio, right? Okay, yes. Valid hai kahin? Is there any provisions? Is there any law?
So minor can also enter into contract by his legal representatives.
Very nice, very good. Okay. Yes. आप देखते होगे ना टीवी सीरियल, है ना, वहां बच्चे एक्ट करते हैं. That is also an agreement by the guardians. Yes, you are right. Okay. Yes, anyone? Voidable है कहीं? I'm talking about present scenario and like and different statute. फिर कॉन्ट्रैक्ट की बात करेंगे. Intensive contract, that is valid or not? Yes, beta, please. Beta, do participate because that part is very, very important.
Repeat the question, sir.
What is the status of minor agreement in present scenario?
It is void.
It is void, right? And any statute which declared it's voidable? Any law? Any law? Hindu Guardianship and Maintenance Act, Section 8, that is talks about voidable agreement if that property is sold by the guardians, you know, and that situations can be the contract can be declared as void at the option of the parties, right? So in the line of the Contract Act, that is void ab initio, right? So the same in India or England, both the different in both the countries, the situation is different, right? So as we know that minors less than 18 years can be treated as minor, right? So minor agreement is void or voidable. That is nothing provided by the Indian Contract Act. The Indian Contract Act is silent on this part, right? So there is a different opinions before 1903. 1903, that is a leading case law, that is Mohri versus Dharmodas case law, in which the case the Privy Council, the highest court of like England, in which is decisions apply in India at that time, right, declares minor agreement is void ab initio. Before that, there are some court in favor of like minors letting agreement is void, minors letting agreement is valid, and minors letting agreement is voidable, right? There is no status and different interpretation made by the courts. But in 1903, the Privy Councils held that the minors letting agreement is ab initio void. Now question arises again, that is decisions made by the Privy Council. Is it India is bound to follow that judgment? Is this judgment, is this precedent, is Indian court is bound to follow this decision? Yes, please. इंग्लैंड की डिसीजंस क्या इंडिया में बाउंड है? इंडिया कोर्ट उसे बाउंड मतलब बाइंडिंग है उससे कि भी वो उसको फॉलो करें?
Not binding.
Not at
No,
all.
not binding.
Right, very good, है ना? Because it's a Supreme Court of India, है ना, जिसको हम follow up करते हैं, है ना? Instead, then we can follow the High Court concern, right? If the precedent made by the Supreme Court, then we are all the courts and subordinate courts in India are bound by law that follow the Supreme Court directions, right? So Supreme Court approved this judgment, means to say the Mohri Bibi judgment in Wali Singh versus Sohan Singh case and Padma Vidhova case. Okay. So Supreme Court, the minors letting agreement is ab initio void, confirmed in both the judgment, right? So that's why we follow this precedent in the present scenario also, right? So in England, yes, please. Yes, beta, you're asking something. Can we continue?
Yes, sir. Please continue.
Yes,
Right.
sir, please.
Okay, so in England, so minors
Yes,
letting
sir.
agreement.
Please continue.
Okay, fine. So minors agreement is voidable contract at the option of the parties, right? If they find the contract advantageous, then the can claim enforceable. Otherwise, if disadvantage, can decide the contract, right? It was the held by Mantine versus Gale case, right? But the situation is changed by the law passed by the England, that is the Infant Relief Act 1874, that declares the minors letting agreement is void, right? In the following cases, the number one is the contract of loan, the second one is contract of account, and the third one is the contract for supply of goods. Like in these agreement, in these contract, right, the contract declared to be void, and the rest of the cases, the contract is voidable, right? So this is the scenario in the England relating to minor agreement, right? So in India, that is different from England, right? So in India, that is the case, that is Moharibi versus Dharmodas. I see. Yes. Can anyone tell me who is the plaintiff in this case? Yes, please. Have you heard about this case? Yes, please.
Yes, sir. Dharmodas Ghosh is plaintiff.
Very good. Okay. Yes. Anyone else? बड़ा ही leading case हुआ बेटा. Whenever you appear in a court and first time, the court, the judge maybe ask from you that have you heard about the Moribibi case? Dharmadas is a like plaintiff or yes. अभी ये हरियाणा जुडिशरी में आया था last time question. The who is the plaintiff in this case? ऐसे क्वेश्चन. Moribibi. हाँ जी, क्यों है जी Moribibi plaintiff इसमें? Because the first name. Yes, beta, please do participate.
It is an appellate case, sir.
Very good. Appellate case. That's why the Mohre will be in first phase. Okay. Very good. So initially the case name of this that was the Dharmodas Ghosh versus Brahmodat. Very right. Dharmodas Ghosh was minor in this case. Sorry, plaintiff in this case. So many students mark it the Mohre because first जो पहला नाम होता है जनरली हम कंसीडर करते दैट इज अ प्लेंटिफ इन दिस केस, राइट? सो कभी मिस्टेक नहीं करना इसमें. सो धर्मदास घोष वाज द प्लेंटिफ इन दिस केस and Brahmodat was defendant, right? So in appeal, Brahmodat versus Dharmadas. The later on, the Brahmodat was dies, and after his death, Morebi Bibi, his representative, right? तो मोहरे बीबी ने इसको केस को रिप्रेजेंट किया था. दैट्स व्हाई द नेम इज मोहरे बीबी वर्सेस धर्मदास केस, राइट? वेरी राइट कि भी अपीलेट केस है, राइट? ओके. So under this case, we will discuss the fact, arguments, issues, and judgment, right? So anyone know about the fact, the briefing fact? Very interesting case, and it's a related to the story or then we will wind up it.
Dharmodas Ghosh wants to money from the money lender. The money lender
Right.
is like Brahmodat is a money lender, like, and
Right, good.
he get 8,000 rupees advance.
Good.
Afterward, Dharmodas Ghosh, mother of the Dharmodas Ghosh, has entered, and she went in a court that minor, the agreement has been done with minor is not in a lawful way.
Right, good. Very right. Excellent. Right. So Dharmodas, as I stated, dear student, excellent. So Dharmodas was a minor and he need some money, then approached to Mahajan. Mahajan here means to say that is Brahmodat. Right. He's generally not available at their home, and he was represented by his agent. That is name is Kedarnath. Right. The Kedarnath was knowing that Dharmodas was minor, and he got a letter of declarations from Dharmodas Ghosh that he is a minor, and agreement of loan made by 20,000, right? So price may be थोड़ा ऊपर नीचे हो सकता है, कभी किसी fact में कुछ stated है, किसी में कुछ है, right? So that is the loan was made rupees 20,000 promised to be given as a loan to the Dharmodas Ghosh. 12,000 immediately, and the two house of the Dharmodas Ghosh got mortgage, right? And 8,000 to be given to the Dharmodas Ghosh later on, right? So two houses थे Dharmodas Ghosh के, उनको उन्होंने mortgage पे करा लिया, right? The Kedarnath know about the fact that the Dharmodas Ghosh was minor, right? And later on, Dharmodas Ghosh mother refused to execute this agreement. राइट, उसने रिफ्यूज कर दिया कि भी दैट ये जो डीड जो आपने बनाई है, जो मॉर्गेज बनाई है, दैट इज दैट मस्ट बी कैंसल्ड, राइट? और उन्होंने एग्जीक्यूट करने से मना कर दिया एंड फाइल ए सूट अगेंस्ट द Dharmodas, right? So these were the fact. Then the argument on the behalf of Dharmodas Ghosh, that mothers on the behalf of Dharmodas, क्योंकि जो Dharmodas था वो तो क्या माइनर था. So that Dharmodas was minor, and minor's agreement is void at that time. 19 के टाइम से उस टाइम पे क्या था, कुछ जजमेंट थी which relate to the minor's lending agreement is void, right? And further, the mortgage deed should be cancelled as per the provision of section 41 of SR 1877, right? और उन्होंने mortgage deed को cancellations के बारे में बात की, right? So agreement on the behalf of Mahajan, that is very interesting argument, that very first. Okay, so very first जो उन्होंने contentions ली that minor's lending agreement is not void, it's voidable, hence the no cancellation of mortgage, right? So void में तो क्या है, cancel हो सकता है, but voidable में क्या है, cancel नहीं हो सकता. So your plea in respect of cancellation of mortgage, that must be denied, right? Secondly, apply theory of estoppel, that minors liable on estoppel and enforceable agreement, right? Means estoppel क्या होता है, do you know बेटा? What do you mean by estoppel?
Preventing from denial.
Very good, है ना? Means to stop someone who making the statement after their statement cannot be denied for that, right? Means जो भी statement करता है कोई person, उसके बाद में वो deny नहीं कर सकता उस statement से, ठीक है? So in this case, ब्रह्मोदत्त ने जो statement दी है कि भी इनके ऊपर estoppel apply होना चाहिए, that is plea raised by the Mahajan, right? Next, the final argument, that is finally the return of benefit of 12,000 rupees. Under section 64 or 65 of Indian Contract Act, he said कि भी ठीक है, हमने इसको कंसिडर किया, void और voidable दोनों कंसिडर कर लोगे, ठीक है? So under section 64, that 12,000 rupees must be restored, and section 65 which is related to voidable contract, means section 64 में क्या है, if the contract is void or the parties who get the benefit then restore the amount. Section 65 in case of voidable, the case means to say in case of voidable, then the parties whatever the amount is gain, means whatever the benefit is gained, ठीक है, must be restored in case of voidable. Means to say void or voidable, यदि हम इसको void भी consider करें या voidable भी, तो हमारे भाई 12,000 रुपीज वो रिटर्न करो, the police मतलब in a court, ठीक है? So according to these plea, आपको क्या लगता है कि भी रिस्टोर होने चाहिए 12,000? Yes. यस बेटा प्लीज। दोनों आर्ग्यूमेंट्स आपके पास है। नाउ यू आर जज। आपके दोनों आर्ग्यूमेंट्स आपके पास हैं, प्रमोदत्त के भी। यस बेटा, रिटर्न होनी चाहिए 12,000 रुपीज। चलो, so the issue before the court, that what very first is, what is the status of minor agreement, whether it is void, voidable or valid. Is what is the status that must be decided by the court. पहले तो ये डिसाइड करो कि कोई कह रहा है कि void, कोई कह रहा है कि voidable, है ना, कोई कह रहा। यस बेटा,
It's a void contract.
issue, I'm just talking about the issues. What was the issues in this case? The court very first decide that whether the minor slating agreement is void, voidable or valid, right? Next one is the whether the theory of estoppel apply in this case or not. The third one, whether the theory of restitutions under section 64 and 65 apply in this case. Next is last one is Mohari Bibi is entitled to get the compensation under section 41 of the SRA, right? So these were the issues जो कोर्ट ने डिसाइड करने थे, राइट? सो क्योंकि हमें पता है फर्स्ट 1903 से पहले कोई स्टेटस नहीं था। कुछ कोर्ट कह रहे हैं कि माइनर स्लेटिंग एग्रीमेंट वॉइड है, कुछ कह रहे हैं वॉइडेबल है, कुछ कह रहे हैं वैलिड है, राइट? सो देयर इज नो लाइक सर्टेन रूल्स इन दिस रिगार्ड, राइट? सो फर्स्ट द कोर्ट हेल्ड दैट द ओल्ड लॉ is not a good law. The minor slating agreement is voidable, not a voidable agreement. It's a void agreement. So the contract void ab initio. Yes, Peter. Please, beta, unmute yourself.
Unmute your mic. Dear students, please mute your mic.
So first, the decision that is minor slating agreement is ab initio void. The second one that is relating to estoppel. So as agent had knowledge that the Dharmodas was minor, and as per the law of agency, the Mahajan has had knowledge of the Dharmodas was minor, right? So truth is known by the both the parties, means truth is known by the both the parties, means parties know about the truth, right? So in this case, the estoppel of theory of estoppel not apply, right? So the court refused that this theory is not applicable in this case because the parties know about the truth. Where is the parties know, or where is law clearly stated that the law, the theory of estoppel will not apply, right? The third one, the theory of restitution, right? No restitution under section 64, right? What it says? Section 64 says that the consequences of rescission of voidable contract, right? So, yes, student, I'm audible.
Yes, sir.
Yes,
Sir.
Okay, the section 64 is very, very important. What it says, the consequences of rescission of voidable contract, right? जैसे प्ले ली थी ना कि भी ये voidable contract है, ये void contract है. So in respect of section 64, it's a voidable, right? So voidable में क्या है लो हमारा? When a person at the whose options at a contract is voidable, resigned it, the other part is there to need not to be performed any promises therein contained in which he is promises. So means to say जो भी benefits लिए हैं parties ने, है ना, वो क्या है, restore करने पड़ेंगे. The parties resigning a voidable shall means mandatory if he had received any benefit thereunder from another party to such contract, restore such benefit. The Brahmodatt and the Mohari Bibi raise this plea. तो भाई ये voidable है, यदि ये voidable कह रहे हैं तो voidable में भी क्या है, section 64 की लाइन है, that is says that benefit must be restored, right? So benefit must be restored, वो होने चाहिए, right? So अब आप बताओ अकॉर्डिंग टू दिस सेक्शंस क्या उसको रिस्टोर होने चाहिए? सेक्शन 64 आपके सामने है. इसमें वर्ड भी लिखा हुआ है shall if he had received any benefit. जो ब्रह्मदत्त ने तो रिसीव किए हैं 12,000 रुपीज, राइट? सो क्या रिस्टोर होने चाहिए? यस बेटा, प्लीज आंसर मी बेटा. रिस्टोर होने चाहिए?
No.
रीजन?
Minor can receive benefit, but he is not bound by any obligations.
Very right. But in the line of this case law, tell me the answer.
रिस्टोर होने चाहिए सर.
Yes, restore होनी चाहिए.
नहीं होने चाहिए. Reasons क्योंकि because of the minors letting agreement is ab initio void. In the first principle, the court held that the minors letting agreement is ab initio void. It's not avoidable, है ना? So in this case, the minors letting agreement क्या है? वो तो void है. So section 64 apply ही नहीं होगा यहाँ पे, है ना? So section 64 not applicable in this case. So court refused this plea, right? उन्होंने मना कर दी because first principle क्या है? Old law, that is very bad law. राइट? सो माइनस लेटिंग एग्रीमेंट क्या है? वो एब इनिशियो वॉइड है, ठीक है? वॉइड एग्रीमेंट पे अप्लाई होगा. सेक्शन 64 है, वो वॉइडेबल पे एप्लीकेबल हो रहा है, राइट? सो दिस सेक्शंस विल नॉट एप्लीकेबल इन दिस केस, राइट? नेक्स्ट आता है हमारा रेस्टिट्यूशन अंडर सेक्शन 65, राइट? इसमें क्या है? ऑब्लिगेशंस ऑफ द पर्संस हु रिसीव्ड एडवांटेज अंडर वॉइड एग्रीमेंट. मींस टू से यदि कोई पार्टीज है वॉइड एग्रीमेंट में कोई बेनिफिट लिया है, क्या वो ये सेक्शन ये कह रहा है द रिस्पेक्टिव पार्टी शेल, है ना, जो भी उसने बेनिफिट्स लिए हैं रिस्टोर द बेनिफिट. अब आप बताओ इसमें होने चाहिए? देखो हेडिंग पढ़ो, ऑब्लिगेशन ऑफ अ पर्सन हु हैज रिसीव एडवांटेज अंडर वॉइड एग्रीमेंट और द कॉन्ट्रैक्ट बिकम वॉइड, राइट? सो the such agreement or contract is bound to restore it. Means whatever the benefits a party have received, right, bound to restore. So according to the case, क्या bound मतलब is Dharmodas is bound to repay the amount?
No,
So
sir.
12,000 rupees. Reason?
Dharmodas is not bound to repay the amount. Reason?
Because it was ab initio.
Very right. Very nice.
Inoperative ab initio.
Right, very good. Because the word and this line यदि आप देखोगे, when agreement is discovered to be void means initially क्या है? Agreement valid होना चाहिए and later on it's become void. But in these situations, in the case of Moribi versus Dharmodas case, the agreement relating to minor is void ab initio, right? So this sections is also not applicable in this case, right? So the doctrine of restitution under section 64 and 65 not applicable in this case, right? And next जो plea under section 41 जो उन्होंने रेज की थी, चलो ठीक है जी यहाँ नहीं अप्लाई हो रहा, तो under section 41. So there is an the doctrine that is he who seek equity must do equity. The court does not apply in this case because the Privy Council applied the principle that he who comes to the court must come with clean hand. जिसको भी relief चाहिए, that come must be with clean hand. The Mahajan was knowing that Dharmodas was minor, and even he know about the fact he got mortgage his property. Right? Intentions of the Mahajan was malified. Means to say the one who come to the court must be clean hand, not apply in this case because of Mahajan intention was malified. His hands are not clean. So Mohari Bibi is not entitled to receive their benefit, so whatsoever the amount उन्होंने pay किया था 12,000, that she is not entitled to get the amount. Right, so this is all about the case of Mohri Bibi versus Dharmodas case, right? So appeal dismissed in this case. Right, beta? Sorry.
Section 68 के अनुसार
जी
minor can get necessaries.
That is different concept. That is under section 68, what it says, that is related to quasi-contract and constructive contract. There is no contract, there is no offer and acceptance. That is an obligations which is created by section 68, right? If the someone supplies to unnecessary necessary supplies to the person who is not entitled to enter into a contract, if that necessary is suited to his life, then the persons is entitled to get the amount from his property. That is constructive contract. That is not a general contract. There is no offer and no acceptance, right? That is different scenario. That is covered under quasi contract, right? Okay, so is doctrine of ratification last? This one is the last. The ratifications means to say that make it regular, what is irregular. The question is that आप मुझे बताओ कि एक minor है, if after getting maturity, suppose the minor make a contract during their minority, right? आपने आंसर करना है, एक प्रॉब्लम दे रहा हूं आपको. During their minority, make a contract relating to sale of goods, right? आप सबको पता है कि minors relating agreement क्या होते हैं, void होते हैं. अब क्या है, after getting maturity, वो कह रहा है कि भी ठीक है, हम इसको एनफोर्स करना चाह रहे हैं. कैन ही डू द सेम?
Yes.
Yes.
ओके, सो देयर इज
when he is due.
बेटा योर वॉइस इज क्रैकिंग.
Because the contract was signed, he was signed at that time.
There is a case. Okay, there is a case. Suresh Narayan versus Sukus Ahir at the Allahabad High Court. In this case, the one cannot be do directly, cannot be do indirectly. अब जो directly means to say during their minority, person is not entitled to enter into a contract. अब after getting majority, can he do the same? Can he confirm? No, that is not applicable. Ratification of doctrine of ratifications cannot be applied retrospectively. It is apply prospectively, right? So, but this cannot be done, right? Irregularities that is relating to mistake and all, that is by the mutual consent of the parties, that can be done according to sections 26 of the SRA, right? And there is a contract ratification relating to like agencies, that is section 96 to 200. That is a different scenario, right? So in this case, in relation to minor, that is not applicable, right? Okay, the theory of restitution एक leading case लो, last one है, इसके बाद हम इसको close करेंगे. That is Leslie versus Sally case. Do you know about this case law? There is a case in simple में थोड़ा सा fact इसको थोड़ा सा बता देता हूँ short में, that minor है जो some discover some amount by misrepresenting his age, कि भी वो age of majority है, right? कि भी मैं 18 above हूँ और उसने 44,000 euro that is get from the parties, right? And after that refuse, and then इसके बाद the parties file a suit against that person's, right? So generally that is no restitution in this case. He has committed fraud. Fine. Okay. So in this case, जहाँ पे generally क्या होता है कि भी misrepresenting वाले case में, there is 3 principles laid down by the court. That very first is, if the minor obtain a property or goods by misrepresenting his age, can ask to restore it, but only long as it is traceable in his possessions. Generally, ठीक है, क्योंकि माइनस लेटिंग एग्रीमेंट क्या होते हैं, वॉइड होते हैं. बट यस, यदि प्रॉपर्टी है और जो गुड्स हैं, दैट इज ट्रेसेबल, that can be recovered. Second one, if the miner has sold the goods or converted it, it cannot be made to repay the value of the goods. Sometimes क्या होता है, property ली by misrepresenting his age और उसने क्या कर दिया, उसको सेल कर दिया और उसको कन्वर्ट कर लिया अपनी मनी में. सो तो भी क्या है, हम उसको रिकवर नहीं कर सकते. राइट नाउ द टॉक्स अबाउट द मनी कैश, है ना, तो उसमें क्या हो सकती है अप्लाई? नो, इन दिस केस आल्सो नॉट एप्लीकेबल. तो थ्योरी ऑफ रेस्टिट्यूशंस, दैट इज the leading case in Leslie versus Sally case, right? So in this case, there is three principles laid down. The very first is, if the goods or property is traceable, then can be restored. यदि उसने fraud commit किया misrepresent करके. Then second, if the property is sold और उसको पैसे में convert कर लिया, then cannot be compelled, right? And the same is the cash obtain किया, उस situation में भी क्या minor को compel नहीं कर सकते हैं, right? द सेम इंडिया में क्या है, इंडिया में मोहरी वर्सेस धर्मोदास केस है, वॉइड एब इश्यू है. नो रेस्टिट्यूशन इन माइनर केसेस, ऑलरेडी डिस्कस इन सेक्शन 64-65. इसके बाद एक केस आया खान गुल वर्सेस लखा सिंह. In this case, the same fact जो अभी डिस्कस किए, इसने fraudulently misrepresent किया and get the sale of plot, and after receiving the consideration amount of 17,500, then he refused to fulfill his bargaining. ठीक है. So in this case, justice held a different view, and इन खानगुल केस जो लेस्ली वर्सेस सैली का केस था, उसको ओवररूल्ड कर दिया, एंड directions made to the against the minor that you have to restore the amount, means to say आपको वो amount रिस्टोर करना पड़ेगा. मीन्स टू से इस केस में क्या है, लेस्ली वर्सेस सैली के केस को ओवरराइड कर दिया. नेक्स्ट विन बड़े लीडिंग केस लो है, आपके सिलेबस में भी होता है, अजूदिया प्रसाद वर्सेस चंदन लाल केस. इन दिस केस द सेम फैक्ट जो अभी हमने डिस्कस किए, मिस रिप्रेजेंट करता है माइनर. देन इस केस में द कोर्ट ओवररूल्ड द खानगुल वर्सेस लखा सिंह जजमेंट, राइट? एंड द सेम द डॉक्ट्रिन ऑफ लेस्ली वर्सेस सैली के केस को इसमें दोबारा इंप्लीमेंट किया ना, दोबारा उसी में जो भी प्रिंसिपल लेट डाउन किए थे. इफ द प्रॉपर्टी इज ट्रेसेबल, देन कैन बी प्रॉपर्टी रिस्टोर. इफ द प्रॉपर्टी कन्वर्टेड इनटू अ मनी, एंड देन कैन नॉट बी ट्रेस. द लास्ट वन इज if the amount is cash, then cannot be claimed, right? So the same issues जो अभी डिस्कस किए हमने. So this is all about from my side. If you have any questions relating to the same, then you can ask me. Yes, any student, if you have any questions relating to the same, you can ask me.
Dear students, if you have any questions,
Any
you can
question,
ask.
beta, any questions?
No, sir. Thank you.
Okay. Thank you,
Do any
student.
question? Okay.
And ma'am,
Aditi?
ma'am.
Yeah. Yes, yes, sir. Okay.
ये स्टूडेंट इज वेरी ब्रिलियंट है ना, हर एक पॉइंट में काफी पार्टिसिपेशन कर रहे हैं. फर्स्ट ईयर स्टूडेंट, आई एम वेरी शॉकिंग कि भाई इतने एक्टिव बच्चे हैं ना, हु टीचिंग द लाइक लॉ ऑफ कॉन्ट्रैक्ट, दैट इज इन राइट पाथ, है ना.
Yes, sir.
So हाँ जी, हाँ जी.
Shall we
Can I
continue?
brief regarding voidable contract? The example of Ranganaikama versus Alvar Shetty. I want to more information regarding voidable contract.
Your issue regarding what?
Which case law?
Case law. Yes, case law. Ranganaikama versus Alvar Shetty.
Ranganaikama.
But
right. What was your issue? मतलब in that case जो भी था बेटा, आपका issue बताओ क्या है? What you want to ask?
मुझे वही केस लॉ इंफॉर्मेशन चाहिए.
ओके, केस लॉ के बारे में पढ़ना है. चलो, दैट इज एन डिफरेंट मैटर. और कुछ पूछना है किसी बच्चे को?
नहीं.
यस बेटा, प्लीज.
Your voice is not clear.
Yes, beta, any questions relating to the same, relating to minority? Any questions? शीतल मैम, इस बच्चे को ना मेरे को पर्सनल दे देना, मैं इसको केस लो, क्योंकि ब्रीफली फैक्ट एंड इश्यूज क्या थे वो सारा डिटेल में मैं इसको बच्चे को समझा दूंगा, ठीक है?
Yes sir, definitely.
Because I have to go somewhere else, right? Because the case is very leading case law, right?
Yes,
and very interesting case law.
Yes sir, definitely. Now I think there is no question. Aditi, now over to you.
Yeah, I just
Yes.
Yes.
Yes, sir.
Your voice is not clear.
Yes, your voice is not clear.
ओके मैम, मैं ये पीपीटी शेयर करता हूँ बच्चों के साथ, मतलब शेयर करते हैं. इफ एनी स्टूडेंट हैव एनी डाउट देन आफ्टर दैट यू कैन, मतलब स्टूडेंट कैन कांटेक्ट टू मी.
Yes sir, okay. Shall we conclude the session, sir?
हाँ जी, yes ma'am, please.
Yes. Aditi, now over to you.
Yes, ma'am. Thank you very much, sir, for your insightful and thought-provoking lecture. Your exploration of the topic contractual competency, understanding capacity and its implications has provided us with a deeper understanding of the complexities surrounding contractual law, its nature, and its impact on our society. As you explained why law requires competency to contract, and the case law examples, including the landmark case Mohari Bibi versus Dharmodas Ghosh, your wealth of knowledge and clear explanation of the nuances of this subject have enriched our perspective and sparked meaningful reflection. We are grateful for the time you took to engage with us and share your expertise. Once again, on behalf of Dayanand Education Society, Dayanand College of Law, Latur, Principal Ma'am and the coordinator of the program, and all the students who joined the session, I would like to extend our heartfelt gratitude to you, sir, for your invaluable contribution to our academic discourse. We hope to have the pleasure of hosting you again in the future, sir. Thank you very much.
Definitely. And thank you, Sheetal ma'am, and thank you, Poonam ma'am, and thank you, Aditi, and for your hosting.
Yes,
And you are first year student or?
Yes, sir. Aditi.
I'm BLLB third year student, sir.
Okay, fine, good, excellent.
Thank you, sir.
Okay, take care.
Thank you, sir.
Okay.
Yes.
मैम, शीतल मैम,
Yes, ma'am. Yes, sir.
एक फोटो, ग्रुप फोटो ले ली थी आपने?
Yes, sir. Screenshot लिए है मैंने.
ठीक है मैम. ओके,
Yes,
थैंक
sir.
यू. ओके मैम, टेक केयर. थैंक यू सो मच.
Okay. Thank you,
एक
sir.
बार और लेते हैं सर.
हाँ जी.
Yes.
पूनम मैम, प्लीज.
Yes. Aditi, you also on your camera.
Please, dear students, you can open your camera. Please switch on your camera.
On your cameras, dear students.
Okay, ji. Thank you, ji. Thank you, everyone. Thank you, Poonam ma'am, once again, and thank you, Sheetal ma'am.
Thank you, sir. Thank you.
Thank you, sir. Thank you.
Okay, ma'am. Take care.
Thank you once again. Yes.
Have a nice day.
Thank you, Sheetal ma'am, and thank you, Poonam ma'am, for arranging such